Okay, thank you this morning. Welcome to Legally Direct, Legally Raven here, and we are going to read the Piper Aircraft Company B. Reyno case. Justice Marshall delivered the opinion to the court. These cases arise out of an air crash that took place in Scotland. Respondents acting as representatives of the estates of several Scottish citizens killed in the accident brought wrongful death actions against petitioners that were ultimately transferred to the United States District Court for the Middle District of Pennsylvania. Petitioners moved to dismiss on the ground of forum nonconvenience. After noting that an alternative form existed in Scotland, the district court granted their motions. The United States Court of Appeals for the Third District reversed. The Court of Appeals based the decision, at least in part, on the grounds that dismissal is automatically barred, where the law of the alternative form is less favorable to the plaintiff than the law of the form chosen by the plaintiff. Because we conclude that the possibility of an unfavorable change in law should not by itself bar dismissal, and we conclude that the district court did not otherwise abuse its discretion, we reverse. In July 1976, a small commercial aircraft crashed in the Scottish Highlands during the course of a charter flight from Blackpool to Perth. The pilot and 5 passengers were killed instantly. The descendants were all Scottish subjects and residents, as are their heirs and next of kin. There were no eyewitnesses to the accident. At the time, the crash of the plane was subject to Scottish air traffic control. The aircraft, a 10-engine Piper Aztec, was manufactured in Pennsylvania by petitioner Piper Aircraft Company. Piper. The propellers were manufactured in Ohio by petitioner Hartzell Propeller Inc. At the time of the crash, the aircraft was registered in Great Britain and was owned and maintained by Air Navigation and Trading Company Limited, Air Navigation. It was operated by McDonald Aviation, a Scottish air taxi service. Both Air Navigation and McDonald were organized in the United Kingdom. The wreckage of the plane is now in a hangar in Farnborough, England. The British Department of Trade investigated the accident shortly after it occurred. A preliminary report found that the plane crashed after developing a spin and suggested that mechanical failure in the plane or the propeller was responsible. At Hartzell's request, this report was reviewed by a 3-member review team, which held a 9-day adversary hearing attended by all interested parties. The review board found no evidence of defective equipment that indicated that pilot error may have contributed to the accident. The pilot, who had obtained his commercial pilot license only 3 months earlier, was flying over high ground at an altitude considerably lower than the minimum height required by the company's operations manual. In July 1977, a California probate court appointed respondent Gaynell Reyno administrator of the estates of 5 passengers. Reyno is not related to or does not know any of the decedents or their survivors. She was a legal secretary to the attorney who filed the lawsuit. Several days after her appointment, Reyno commenced several wrongful death actions against Piper and Hartzell in the Superior Court of California, claiming negligence and strict liability. Air Navigation, McDonald, and the estate of the pilot are not parties to this litigation. The survivors of the 5 passengers whose estates are represented by Reyno filed a separate action in the United Kingdom against air navigation McDonald, and the pilot's estate. Reyno candidly admits that the action against Piper and Hartsell was filed in the United States because its laws regarding liability, capacity to sue, and damages are more favorable to her position than those of Scotland. Scottish law does not recognize strict liability in tort. Moreover, it permits wrongful death actions only when brought by decedent's relatives. The relatives may sue only for loss of support in society. On petitioner motion, the suit was removed to the United States District Court. But on petitioner's motion, the suit was removed to the United States District Court for the Central District of California. Piper then moved to transfer to the United States District Court for the Middle District of Pennsylvania, pursuant to 28 U.S.C. 1404A. Hartsell moved to dismiss for lack of personal jurisdiction or in the alternative to transfer. The district court concluded that it could not assert personal jurisdiction over Hartsell consistent with due process. However, it decided not to dismiss Hartsell because the corporation would be amenable to process in Pennsylvania. In May 1978, after the suit had been transferred, Hartsell and Piper moved to dismiss on the ground of forum nonconvenience. The district court granted these motions in October 1979. It relied on the balancing test set forth by the court in Gulf Oil v. Gilbert in 1947 in its companion case Custer v. Lumbermen's Case Company 333 U.S. 518, 1947. In those decisions, the court stated that a plaintiff's choice of forum should rarely be disturbed. However, when an alternative forum has jurisdiction to hear cases, and when trial in the chosen forum would establish oppressiveness and vexation to the defendant out of all proportion to plaintiff's convenience, and when the chosen forum is appropriate because of the considerations affecting the court's own administration and legal problems, the court may, in the exercise of its sound discretion, dismiss the case. Coaster Supra at 524. To guide court discretion, the court provided a list of private interest factors affecting the convenience of such litigants and a list of public interest factors affecting the convenience of the forum. The facts pertaining to the private interests of litigants included the relative ease of access to sources of proof, availability of compulsory process for attendance of unwilling, and the cost of obtaining attendance of willing witnesses, possibility of view of premise. If you would be appropriate in the actions and all other practical problems that make trial of a case easy, expeditious, and inexpensive. Gilbert. The public factors bearing on the question included the administrative difficulties flowing from court congestion, the local interest in having localized controversies decided at home, the interest in having the trial of a diversity case in a forum that is at home with the law that must govern the action, the avoidance of unnecessary problems and conflict of laws, and the application of foreign law. and the unfairness of burdening citizens in an unrelated forum with jury duty. After describing our decisions in Gilbert and Coaster, the district court analyzed the facts of these cases. It began by observing that an alternative form existed in Scotland. Piper and Hartzell had agreed to submit to the jurisdiction of the Scottish courts and to waive any statute of limitations defense that might be available. It then stated that plaintiff's choice of form was entitled to little weight. The court recognized that a plaintiff's choice ordinarily deserves substantial deference. It noted, however, that Reyno is a representative of foreign citizens and residents seeking a forum in the United States because of more liberal rules concerning product liability law, and the courts have been less solicitous when plaintiff is not an American citizen or resident, and particularly when the foreign citizens seek to benefit from the more liberal tort rules provided for protection of citizens and residents of the United States. The district court next examined several factors relating to private entrance of litigants and determined that 3 factors strongly pointed towards Scotland as the appropriate forum. Although evidence concerning the design, manufacture, and testing of the plane propeller is located in the United States, the connections with Scotland are otherwise overwhelming. The real parties and interests are citizens of Scotland, as were their decedents. Witnesses who could testify regarding the maintenance of the aircraft, the training of the pilot, and the investigation of the accident, all essential to the events, are in Great Britain. Moreover, all witnesses to damages are located in Scotland. Trial would be aided by familiarity with Scottish topography and easy access to the wreckage. The district court reasoned that because crucial witnesses and evidence were beyond the reach of compulsory process, and because the defendants would not be able to plead potential Scottish third-party defendants, it would be unfair to make Piper and Hartzell proceed to trial in this forum. The survivors had brought separate actions in Scotland against the pilot, McDonald, and air navigation. It would be fair to all parties and less costly if the entire case was presented to one jury with available testimony from all relevant witnesses. Although the court recognized that if trial were held in the United States, Piper and Hartzell could file indemnity or contribution actions against the Scottish defendants, it believed that there was a significant risk of inconsistent verdicts. The district court explained that inconsistent verdicts might result if petitioners were held liable on the basis of strict liability here and then required to prove negligence in an indemnity action in Scotland. Moreover, even if the same standard of liability applied, there was a danger that different juries would find different facts and produce inconsistent results. The district court concluded that the relevant public interest also pointed strongly toward dismissal. The court determined that Pennsylvania law would apply to Piper and Scottish law to Hartzell if the case were trial in the Middle District of Pennsylvania. As a result, trial in this forum would be hopelessly complex and confusing to a jury. In addition, the court noted that it was unfamiliar with Scottish law and thus will have to rely on experts from the country. The court also found that the trial would be enormously costly and time-consuming, that it would be unfair to burden the citizens with jury duty, in the Middle District of Pennsylvania has little connection with the controversy, and Scotland has a substantial interest in the outcome of the litigation. In opposing the motion to dismiss, respondent contended that dismissal would be unfair because the Scottish law was less favorable. The district court explicitly rejected this claim and reasoned that possibility that dismissal might lead to an unfavorable change in law did not deserve significant weight. Any deficiency in foreign law was a matter to be dealt with in a foreign forum. On appeal, the United States Court of Appeal for the Third Circuit reversed and remanded the trial. The decision to reverse appears to be based on 2 alternative grounds. First, the court held that the district court abused its discretion in conducting the Gilbert analysis. Second, the court held that dismissal is never appropriate where the law of the alternative forum is less favorable to the plaintiff. The Court of Appeals began its review of the district court's Gilbert analysis by noting that the plaintiff's choice of forum deserves substantial weight, even though the real parties and interests are not residents. It then rejected the district court's balancing of the private interests. It found that Piper and Herschel had failed adequately to support their claim that key witnesses would be unavailable if trial were held in the United States. They had never specified the witnesses they would call and the testimony these witnesses would provide. The Court of Appeals also gave little weight to the fact that Piper and Herschel would not be able to implead potential Scottish third-party defendants, reasoning that the difficulty would be burdensome, not unfair. Finally, the court stated that resolution to the suit would not be significantly aided by familiarity with Scottish topography or by viewing the risk wreckage. The Court of Appeals also rejected the district court's analysis of the public interest factors. It found that the district court gave undue emphasis to the application of Scottish law. The mere fact that the court is called upon to determine and apply foreign law does not present a legal problem of the sort that would justify the dismissal of a case otherwise properly done before the court. In any event, it believed that Scottish law need not be applied. After conducting its own choice of law analysis, the Court of Appeals determined that American law would govern the actions against both Piper and Herschel. The same choice of law analysis apparently failed to conclude that the same choice of law analysis apparently led it to conclude that Pennsylvania and Ohio, rather than Scotland, are the jurisdiction with the greatest policy interest in the dispute, and that all other public interest factors favored the trial in the United States. In any event, it appears the Court of Appeals would have reversed even if the district court had properly balanced the public and private interest. The court stated, it is apparent that the dismissal would work a change in the applicable law so that the plaintiff's strict liability claim would be eliminated from the case. But a dismissal for forum nonconvenience, like a statutory transfer, would not, despite its convenience, result in a change in the applicable law. Only when American law is not applicable or when the foreign jurisdiction would, as a matter of its own choice of law, give the plaintiff, only when American law is not applicable or when the foreign jurisdiction would, as a matter of its own choice of law, give the plaintiff the benefit of a claim to which she is entitled here, would dismissal be justified. In other words, the court decided that dismissal is automatically barred if it would lead to a change in the applicable law unfavorable to the plaintiff. We granted certiorari to consider questions concerning the proper application of the doctrine of forum nonconvenience. The Court of Appeals erred in holding that plaintiffs may defeat a motion to dismiss on grounds of forum nonconvenience merely by showing that the substantive law would be applied in the alternative form is less favorable to the plaintiffs than that of the present form. The possibility of a change in substantive law should ordinarily not be given conclusive or even substantial weight. In a forum nonconvenience inquiry, we expressly rejected the position adopted by the Court of Appeals in our decision in Canada, Malting Company v. Patterson Steamships. That case arose out of a collision between two vessels in American waters. The Canadian owners of cargo lost in the accident sued the Canadian owners of one of the vessels in federal district court. The cargo owners chose an American court in large part because of the relevant American liability rules more favorable than the Canadian rules. The district court dismissed on the grounds of forum nonconvenience. The plaintiff argued that dismissal was inappropriate because Canadian laws are favorable to them. The court nonetheless affirmed, we have no occasion to inquire by what law the rights of parties are governed, as we are in the opinion that under the view of that question, it lay within the discretion of the district court to decline to assume jurisdiction over the controversy. The court will not take cognizance of the case if justice would be as well done by remitting the parties to their home forum. Okay. It is true that Canada, Malting was decided before Gilbert, and that the doctrine of forum nonconvenience was not fully crystallized until our decision in that case. In previous forum nonconvenience decisions, the court has left unresolved the question whether under Erie R. Company v. Tompkins 304 U.S. 64 1938, state or federal law of forum nonconvenience applies in a diversity case. Gilbert 330 U.S. at 509. The court did not decide this issue because the same result would have been reached in each case under federal or state law. The lower courts in these cases reached the same conclusion. Pennsylvania and California law on forum nonconvenience dismissals are virtually identical to federal law. C 630 Federal 2D 158. Thus, also here, we need to resolve the Erie question. However, Gilbert in no way affects the validity of Canada malting. Indeed, by holding that the central focus of the forum nonconvenience inquiry is convenience, Gilbert implicitly recognized that dismissal may not be barred solely because of the possibility of an unfavorable change in law. Under Gilbert, dismissal will ordinarily be appropriate when where trial in the plaintiff's chosen form imposes a heavy burden of the defendant or the court, and where the plaintiff is unable to offer any specific reasons of convenience supporting his claim. In other words, Gilbert held that dismissal may be warranted where a plaintiff chooses a particular form not because it is convenient, but solely in order to harass the defendant or take advantage of favorable law. This is precisely the situation the Court of Appeal were barred to dismiss. If substantial weight were given to the possibility of an unfavorable change of law, however, dismissal might be barred even where trial in the chosen form were plainly inconvenient. The Court of Appeal's decision is inconsistent with the court's earlier forum nonconvenience decision in another respect. Those decisions have repeatedly emphasized the need to retain flexibility. In Gilbert, the court refused to identify specific circumstances which those decisions have repeatedly emphasized the need to retain flexibility. In Gilbert, the court refused to identify specific circumstances which will justify or require either grant or denial of the remedy. Similarly, in Coaster, the court rejected the contention that where a trial would involve inquiry into internal affairs of a foreign corporation, dismissal was always appropriate. That is one but only one factor which may show convenience. We stated that we should not lay down a rigid rule to govern discretion and that each case turns on its facts. If central emphasis were placed on any one factor, the forum nonconvenience doctrine would lose much of the very flexibility that makes it so valuable. Oh, it being one factor. Yeah. In fact, if conclusive and substantial weight were given to the possibility of a change of law, the forum nonconvenience doctrine would become virtually useless. Jurisdictions and venue requirements are often easily satisfied. As a result, many plaintiffs are available to choose from among several forms. Ordinarily, these plaintiffs will select the form whose choice of borrowers are most advantageous. Thus, the possibility of unfavorable change in substantive law is given substantial weight in the forum nonconvenience inquiry. Dismissal will rarely be proper. Except for the court above, every federal court of appeals that has considered this question after Gilbert has held that dismissal on grounds of forum nonconvenience may be granted, even though the law applicable to alternative form is favorable to the plaintiff's chance of recovery. Several courts have relied expressly on Canada malting to hold that the possibility of an unfavorable change of law should not by itself bar dismissal. The Court of Appeals approach is not only inconsistent with the process of forum nonconvenience doctrine, but also poses substantial practical problems. If the possibility of a change is not consistent with the process of substantial problems. If the possibility of a change in law were given substantial weight, deciding motions to dismiss on the grounds of forum nonconvenience would become quite difficult. Choice of law analysis will become extremely important, and the courts will frequently be required to interpret the law of foreign jurisdictions. First, the trial court will have to determine what law would apply if the case were tried in the chosen form, and then what law would apply in alternative form. It would then have to compare the rights, remedies, and procedures available under the law that would be applied in each form. Dismissal would be appropriate only if the court concluded that the law applied in alternative form is as favorable to the plaintiff as the chosen form. The doctrine of forum nonconvenience, however, is designed in part to help courts avoid conducting complex exercises in comparative law. As stated in Gilbert, the public interest factors point towards dismissal, where a court would be required to untangle problems of conflict of law in foreign law itself. Upholding the decision of the Court of Appeals would result in another practical problem, at least where the foreign plaintiffs named an American manufacturer as defendant. In fact, the defendant might not even have to be American. A foreign plaintiff seeking damages for an accident that occurred abroad might be able to obtain service of process on a foreign defendant who does business in the United States. Under the Court of Appeals holding, dismissal would be barred if the law of the alternative form were less favorable to the plaintiff, even though none of the parties are American, and even though there's absolutely no nexus between the subject matter of the litigation and the United States. Also, if a person is randomly on vacation in America and the law in America is better, you could serve them here and then they could go to court here because of jurisdiction here if this is the way that this law was allowed to be interpreted. Is what I think that means. Okay. A court could not dismiss the case on grounds of foreign nonconvenience, where dismissal might lead to an unfavorable change of law. The American courts, which are already extremely attractive to foreign plaintiffs, would become more attractive. The flow of litigation into the United States would increase and further congest already crowded courts. First, all but 6 of the 50 American states offer strict liability. Rules roughly equivalent to American strict liability are effective in France, Belgium, and Luxembourg. West Germany and Japan have strict liability statute for pharmaceuticals. However, strict liability remains primarily an American innovation. Second, the tort plaintiff may choose, at least potentially, from among 50 jurisdictions he decides to follow suit in the United States. Each of these jurisdictions applies its own specific malleable choice of law rules. Third, jury trials are almost always available in the United States, while they are never provided in civil law jurisdictions. Even in the United Kingdom, most civil actions are not tried before a jury. Fourth, unlike foreign jurisdictions, American courts allow contingent attorney fees and do not tax losing parties with their opponent's attorney fees. Fifth, discovery is more extensive in America than in foreign courts. The American courts are extremely attractive to foreign plaintiffs, so become even more attractive. The flow of litigation into the United States would increase and further congest already crowded courts. 19. In holding that the possibility of a change of law unfavorable to the plaintiff should not be given substantial weight, we also necessarily hold up that the possibility of a change of law favorable to the defendant should not be considered. Respondents suggest that Piper and Hertel filed the motion to dismiss not simply because trial in the United States would be inconvenient, but also because they believe the laws of Scotland are more favorable. She argues that this should be taken into account in the analysis of private interests. We recognize, of course, that Piper and Hertel may be engaged in reverse forum shopping. However, the possibility ordinarily should not enter into the trial court's analysis of private interests. If the defendant is able to overcome the presumption in favor of plaintiff by showing that trial in the chosen form will be unnecessarily burdensome, dismissal is appropriate regardless of the fact the defendant may be motivated by a desire to obtain a more favorable forum. The Court of Appeals based its decision, at least in part, on an analogy between dismissal on the ground of forum nonconvenience and transfer between federal courts pursuant to 1404. In Van Dusen v. Barrick, the court ruled in Section 1404A, transfer should not result in a change of applicable law. Relying on dictum in an earlier third court opinion interpreting Van Dusen, the court held that the principle is also applicable to a dismissal on forum nonconvenience grounds. However, 1404A transfers are different than dismissal on the ground of forum nonconvenience. Let me look up the word dictum again. A formal pronouncement from an authoritative source. The First Amendment dictum that Congress shall make no law abridging the freedom of speech. Great. The Court of Appeals based its decision, at least in part, on the analogy between dismissal on the ground of forum nonconvenience and transfer between federal courts pursuant to 1404A. And Van Dusen v. Barrick, the court ruled that a 1404A transfer should not result in the change of applicable law. Relying on dictum in an earlier Third Circuit opinion interpreting Van Dusen, the court below held that principle is also applicable to a dismissal on forum nonconvenience grounds. However, 1404A transfers are different than dismissals on the ground of forum nonconvenience. Congress enacted 1404A to permit change of venue between federal courts. Although the statute was drafted in accordance with the doctrine of forum nonconvenience, it was intended to be a revision rather than a codification of the common law. District courts were given more discretion to transfer under 1404A than they had to dismiss on grounds of forum nonconvenience. The reasoning employed in Van Dusen v. Barrick is simply applicable to dismissal. The reasoning employed on Van Dusen v. Barrick is simply inapplicable to dismissal on grounds of forum nonconvenience. The case did not dismiss the common law doctrine, rather it focused on the construction and application of Section 1404A, 376 U.S. at 613. Emphasizing the remedial purpose of statute, Barrett concluded that Congress could not have intended a transfer to be accompanied by a change of law. The statute was designed as a federal housekeeping measure, allowing easy change of venue within a unified federal system, 613. The court feared that if a change in venue were accompanied by a change in law, forum shopping parties would take unfair advantage of the relaxed standards for transfer. The rule was necessary to ensure that just and efficient operation of the statute. We do not hold that the possibility of an unfavorable change of law should never be a relevant consideration of forum nonconvenience inquiry. Of course, if the remedy provided by the alternative form is so clearly inadequate or unsatisfactory that it is no remedy at all, the unfavorable change of law may be given substantial weight. The district court may conclude that dismissal would not be in the interest of justice. At the outset of any forum nonconvenience inquiry, the court must determine whether there exists an alternative forum. Ordinarily, this requirement will be satisfied when the defendant is amenable to process in the other jurisdiction, Gilbert, 330 U.S. 506, 507. In rare circumstances, however, where the remedy offered by the other forum is clearly unsatisfactory, the other forum may not be an adequate alternative and initial requirement may not be satisfied. Thus, for example, dismissal would not be appropriate where the alternative forum does not permit litigation of the subject matter in dispute. Court refuses to dismiss where the alternative forum is Ecuador. It is unclear whether Ecuadorian tribunal will hear the case, and there is no generally codified Ecuadorian legal remedy for the unjust enrichment of tort claims disorder. Also, this is Canada Oil versus Texaco. Court refuses to dismiss where alternative forum is Ecuador. It is unclear whether Ecuadorian tribunal will hear the case, and there is generally no codified Ecuadorian legal remedy. All right, so in that case, they didn't transfer because the place that they would have transferred to didn't have a legal remedy for this stuff. In these cases, however, the remedies that would be provided by the Scottish courts do not fall in this category. Although the relatives of the decedents may not be able to rely on strict liability theory, and although their potential damages awards may be smaller, there is no danger that they will be deprived of any remedy or treated unfairly. So in Ecuador, in this case, what was the case? In um, Phoenix Canada Oil v. Texaco, they didn't transfer to Ecuador because they felt like the Ecuador might not even give them any chance for justice. Whereas in Scotland, it's like we don't like it as much as the United States, but they will hear the case, and you might not get as much money, but there is the opportunity for you to receive justice. The Court of Appeals also erred in rejecting the district court's Gilbert analysis. The Court of Appeals stated that more weight should be given to the plaintiff's choice of forum and criticized the district court's analysis of private and public interest. However, the district court decision regarding the deference to plaintiff's choice of forum was appropriate. Furthermore, we do not believe the district court abused its discretion in weighing the private and public interest. The district court acknowledged that there is ordinarily a strong presumption in favor of the plaintiff's choice of forum, which may be overcome only when private and public interest factors could be pointed towards the alternative forum. It held, however, that the presumption applies with less force when the plaintiff or real parties in interest are foreign. The district court acknowledged that there is ordinarily a strong presumption in favor of the plaintiff's choice of forum, which may be overcome only when the private and public interest factors clearly point towards the trial and alternative forum. It held, however, that the presumption applies with less force when the plaintiff or real parties in interest are foreign. The district court's distinction between resident or citizen plaintiffs and foreign plaintiffs is fully justified. In Coaster, the court indicated that a plaintiff's choice of forum is entitled to greater deference when the plaintiff has chosen the home forum. Citizens or residents deserve somewhat more deference than foreign plaintiffs, so dismissal should not be automatically barred when a plaintiff has filed suit in his home forum. As always, if the balance of conveniences suggests that trial in the chosen forum would be unnecessarily burdensome for the defendant of the court, dismissal is proper. When the plaintiff is foreign, however, this assumption is much less reasonable because the central purpose of any forum nonconvenience inquiry is to ensure that the trial is convenient. A foreign plaintiff's choice observes less deference. Okay, because they're foreign anyway. So it's like, yeah, they chose this forum, but it's not because it's convenient because they're foreign. The forum nonconvenience determination is committed to the sound discretion of the court. It may be reversed only when there has been a clear abuse of discretion, where the court has considered all relevant public and private interest factors, and where its balancing of these factors is reasonable. Its decision deserves substantial deference. Here, the Court of Appeals expressly acknowledged that the standard review was one of abuse of discretion. In examining the district court's analysis of the public and private interest, however, the Court of Appeals seemed to have lost sight of this rule and substituted with its own judgment for that of the district court. One, in analyzing the private interest factors, the district court stated that connections with Scotland are overwhelming. This characterization may be somewhat exaggerated, particularly with respect to the question of relative ease of access of sources of proof. Private interest point in both directions. As respondents' emphasis records concerning the design, manufacture, and testing of the propellant and planer located in the United States, she will have greater access to sources of proof relevant to her strict liability and negligence theories if the trial was held here. However, the district court did not act unreasonably in concluding that fewer evidentiary problems would be posed if the trial was held in Scotland. A large portion of the relevant evidence is located in Great Britain. The Court of Appeals found that the problems of proof could not be given any weight because Piper and Hartzell failed to describe with specificity that evidence would not be able to be obtained if the trial was held in the United States. It suggested that defendants seeking forum nonconvenience dismissals must submit affidavits identifying the witnesses they would call and the testimony these witnesses will provide if the trial was held in an alternative forum. Such detail is not necessary. Piper and Hartzell have moved to dismiss precisely because many crucial witnesses are located beyond the compulsory process and thus the difficulty to identify or interview. Requiring extensive investigation would defeat the purpose of their motion. Of course, defendants must provide enough information to enable the district court to balance the parties' interests. Our examination of the record convinces us that sufficient information was provided here. Both Piper and Hartzell submitted affidavits describing the evidentiary problems they would face if the trial were held in the United States. The affidavit provided by the district court by Piper states that it would call the following witnesses: the relatives of the decedents, the owners and employers of McDonald, the persons responsible for training and licensing the pilot, the persons responsible for servicing and manufacturing the aircraft, and 2 or 3 of his own employees involved in the design and manufacture of the aircraft. Our examination of the record convenience commences thus that sufficient information was provided here. Both Piper and Hartzell submitted affidavits describing the evidentiary problems they would face if trial were held in the United States. The district court correctly concluded that problems posed by the inability to implead potential third-party defendants clearly supported holding in Scotland. Joinder of the pilot's estate, air navigation, McDonald, is crucial to the presentation of petitioner's defense. If Piper and Hartzell can show that the accident was caused not by a defect in design, but rather by the negligence of the pilot, the plane's owners or the charter company will be relieved of all liability. It is true, of course, that Hartzell and Piper were found to be liable after a trial in the United States. If they were found to be liable on trial in the United States, they could institute an action of indemnity or contribution against these parties in Scotland. It would be far more convenient, however, to resolve all claims in one trial. The Court of Appeals rejected this argument, forcing petitioners to rely on actions for indemnity or contributions would be burdensome, but not unfair. Finding that trial in the plaintiff's chosen forum would be burdensome, however, is sufficient to support dismissal on grounds of forum nonconvenience. The district court's review of the factors relating to public interest was also reasonable. One of the bases of its choice of law analysis, it concluded that if the case were trial in the Middle District of Pennsylvania, Pennsylvania law would apply to Piper's Scottish law to Hartzell. It stated that a trial involving 2 sets of laws would be confusing to the jury. It also noticed its own lack of familiarity with Scottish law. Consideration of these problems was clearly appropriate under Gilbert, and the case explicitly held that the need to apply foreign law pointed toward dismissal. Many forum nonconvenience decisions have held that the need to apply foreign law favors dismissal. Of course, the factor alone is not sufficient to warrant dismissal when balancing of all relevant factors show that the plaintiff's choice of forum is appropriate. The Court of Appeals found the district courts of law analysis was incorrect and that American law would apply to both Hartzell and Piper. Thus, lack of familiarity with foreign law would not be a problem. Even if the Court of Appeals conclusion is correct, however, all the public interest factors favor trial in Scotland. Scotland has a very strong interest in this litigation. The accident occurred in its airspace. All the decedents are Scottish. Apart from Piper and Hartzell, all potential plaintiffs and defendants are either Scottish or English. As we stated in Gilbert, there is a local interest in having localized controversies decided at home. Respondents argue that American citizens have an interest in ensuring American manufacturers are deterred from producing defective products, and that additional deterrence might be attained if Piper and Hartzell were tried in the United States, where they could be sued on the basis of both negligence and strict liability. However, incremental deterrence that would be gained if the trial were held in an American court is likely to be insignificant. The American interest in this accident is simply not sufficient to justify the enormous commitment of judicial time and resources that would inevitably be required if the case were tried here. The Court of Appeals erred in holding that the possibility of an unfavorable change in law bars dismissal on the ground of forum nonconvenience. It also erred in rejecting the district court's Gilbert analysis. The district court properly decided that the presumption in favor of the respondent's forum choice applied with less than maximum force because the real parties and the interests are foreign. It did not act unreasonably in deciding that the private interest pointed towards trial in Scotland, nor did it act unreasonably in deciding that public interests favored trial in Scotland. Thus, the judgment of the Court of Appeals is reversed. Justice Powell took no part in the decision of these cases. Justice O'Connor took no part in the consideration decision of these cases. Justice White concurring in part and dissenting in part. I join parts 1 and part 2 of the court's opinion. However, like Justice Brennan and Justice Stevens, I would not proceed to deal with issues addressed in part 3. To that extent, I am in dissent. Justice Stevens become Justice Brennan joins dissenting. Having decided that a court can dismiss the case even though the other forum will apply law that is less favorable to the plaintiff, I would simply remand the case to the Court of Appeals for further consideration of the question whether the district court correctly decided that Pennsylvania was a non-convenient forum. Notes and question. Understanding forum nonconvenience. Rationale for the forum nonconvenience doctrine. Why should courts have the ability to grant a forum? Okay, we're going to stop here and we will finish later today this chapter, picking up with the notes and questions, understanding forum nonconvenience section. Thank you for tuning in to today's episode of Legally Narrate, Legally Raven-haired.